Welcome to Context 101. Please subscribe and hit the bell icon for more breaking updates. The ground beneath America's gun debate has shifted, marking a pivotal moment in the nation's ongoing struggle to define the boundaries of the Second Amendment. For decades, the question of who can carry firearms, and where, has been fiercely contested in courts, legislatures, and communities across the country. On January 8, 2026, the Ninth U.S. Circuit Court of Appeals delivered a landmark decision, striking down California's long-standing ban on open carry. This ruling sent shockwaves nationwide, reverberating far beyond the borders of the Golden State and igniting passionate debate from coast to coast. The court's decision is deeply rooted in the Supreme Court's 2022 Bruin decision, which fundamentally altered the legal landscape for gun rights. By challenging not just a single state law, but the very foundation of modern gun control, the Ninth Circuit has set the stage for a new era of legal battles and policy shifts. The Bruin decision requires that any gun regulation must be consistent with the nation's historical firearm traditions. This means that courts are now compelled to look back to the 18th century for guidance, examining how firearms were regulated, or not regulated, at the time the Constitution was written. This historical test has made it much harder for modern gun control laws to withstand judicial scrutiny. For millions of people living in densely populated cities like Los Angeles and San Francisco, the prospect of open carry is no longer a distant hypothetical. It's a real and immediate possibility. Residents, business owners, and local officials are now grappling with what this change could mean for public safety, community life, and the daily experience of urban living. Gun rights advocates are celebrating this decision as a monumental victory, seeing it as a restoration of constitutional freedoms that have long been restricted. Meanwhile, California officials are weighing their next move, which could include appealing the decision to the Supreme Court, or seeking new legislative solutions to address concerns about public safety. The outcome of this legal battle will set a powerful precedent, shaping gun policy not just in California, but across the entire country. Other states with strict gun laws are watching closely, knowing that their own regulations could soon face similar challenges. As the nation stands at this crossroads, the Second Amendment debate has entered a new, transformative chapter, one that will define the future of gun rights and regulations in America for years to come. California's strict gun laws didn't appear overnight. They evolved gradually over many decades, shaped by a complex mix of social, political, and cultural forces unique to the state. The story of gun control in California is a reflection of the broader American struggle to balance public safety with individual rights, and it's a history marked by moments of crisis, activism, and legislative change. In the 1960s, California was a hotbed of social upheaval, with protests and demonstrations erupting across the state. These turbulent times forced lawmakers to confront the realities of gun violence and public fear, prompting a series of political responses that would shape the future of gun legislation. One pivotal moment came in 1967, when the Black Panthers staged armed protests at the state capitol to challenge police brutality and assert their rights. The sight of citizens openly carrying loaded firearms alarmed both the public and politicians. In response, the state passed the Mulford Act, which banned the open carry of loaded guns in public. Then, Governor Ronald Reagan signed the law, marking a significant turning point in California's approach to gun control. Although the Mulford Act was initially a reaction to a specific movement, its impact rippled outward. Over the years, California expanded its restrictions, aiming to limit the presence of firearms in public spaces and reduce the risk of violence. Law enforcement began to enforce these new rules, and "No Guns Allowed" signs became a common sight in cities and towns. By 2012, lawmakers closed remaining loopholes by banning the open carry of even unloaded handguns. This move was justified by citing growing public anxiety and the need to ensure safety in communities. The new law was met with both support and protest, as some saw it as a necessary step, while others viewed it as an overreach. These cumulative laws resulted in a near-total ban on open carry throughout the state. Critics, including gun rights advocates, argued that California's approach had gone too far, effectively erasing the constitutional right to bear arms in public. They organized rallies, voiced their concerns, and challenged the laws in the court of public opinion. Meanwhile, the state's permit system for concealed carry was notoriously difficult to navigate. For many residents, obtaining a permit was nearly impossible, making the right to carry a firearm in public more theoretical than real. Gun stores saw fewer customers, and citizens grew frustrated with the bureaucracy. All of these developments set the stage for a new chapter, a legal battle that would challenge California's restrictions and force the courts to reconsider the balance between public safety and individual rights. The Ninth Circuit's ruling was a legal bombshell, sending shockwaves through both legal and political circles across the country. The decision didn't just impact California, it immediately raised questions about the future of gun regulations in other states within the Ninth Circuit's jurisdiction, which includes much of the western United States. Legal experts, lawmakers, and advocacy groups on both sides of the gun debate scrambled to interpret the implications, knowing that the outcome could set a powerful precedent. The court declared California's open carry ban unconstitutional, striking at the heart of one of the nation's strictest gun control measures. This ruling challenged the state's long-standing approach to regulating firearms in public spaces and immediately sparked heated debate among residents, officials, and activists. Judge Lawrence Van Dyke's majority opinion took a controversial approach. Rather than weighing modern public safety concerns or the unique challenges faced by California, he focused almost exclusively on historical context. The opinion meticulously examined whether similar open carry bans existed in the 18th and 19th centuries, the eras when the Second Amendment was written and interpreted by the courts. By looking to the past, Van Dyke argued that the Constitution's original meaning should guide today's laws, even if that means overturning modern regulations. Finding no historical precedent for such a sweeping ban, the court concluded that California's law could not survive under the Supreme Court's Bruin test. The Bruin decision, handed down in 2022, requires that any gun regulation must be consistent with the nation's historical tradition of firearm regulation. This test has become a powerful tool for challenging modern gun laws, and the Ninth Circuit's application of it here could have far-reaching consequences. The case was brought by Mark Baird, a gun rights advocate who argued that California's strict laws left him with no legal way to carry a firearm for self-defense. Baird's challenge resonated with many gun owners who feel that their rights are being eroded by increasingly restrictive state laws. His legal battle became a rallying point for those who believe the Second Amendment guarantees not just the right to own a gun, but to carry it openly in public. The court ultimately agreed with Baird, calling California's open carry ban a deprivation of core Second Amendment rights. The decision emphasized that the right to bear arms is not a second-class right, and that states cannot simply ban public carry without strong historical justification. This language sent a clear message to other states with similar laws. Their regulations could soon face similar challenges. For now, the ruling is on hold as California's Attorney General weighs the next move. The state could request an en banc review, asking a larger panel of Ninth Circuit judges to reconsider the decision, or it could appeal directly to the U.S. Supreme Court. Both options carry significant risks and could shape the future of gun laws nationwide. With the Supreme Court's current conservative majority, gun control advocates are bracing for the possibility that the justices could use this case to further expand Second Amendment protections. If the court takes up the case, it could set a new national standard, making it even harder for states to justify strict gun regulations. The next steps in this legal battle will determine whether the Ninth Circuit's ruling remains a regional decision affecting only Western states, or becomes a national precedent that reshapes gun laws across America. Other states are watching closely, knowing that their own regulations could soon be challenged. The legal landscape for gun laws is now in flux, with courts, lawmakers, and citizens all waiting to see how this pivotal case will shape the future of the Second Amendment in the United States. The Ninth Circuit's decision traces back to the Supreme Court's 2022 Bruin ruling, which upended how courts judge Second Amendment cases. Bruin replaced decades of balancing public safety with rights, demanding that gun laws match the nation's historical tradition. Courts now ask, does the Second Amendment's text cover the conduct, and is the regulation historically grounded? This history-only approach has forced judges into the role of historians, searching for 18th-century analogs to modern laws. Critics argue this is unworkable, given the vast differences between colonial America and today's society. The Bruin test has led to conflicting lower court rulings and confusion over modern gun laws. The Ninth Circuit's application of Bruin signals that regulations lacking historical roots are at risk. The Ninth Circuit's decision isn't yet in effect, California is expected to appeal, pausing any immediate changes. If upheld, the state would have to allow open carry permits statewide, including in major cities. This would mark a dramatic shift for urban Californians, who haven't seen open carry in generations. Law enforcement, businesses, and the public would face new logistical and social challenges. Many gun owners may still prefer concealed carry, and major retailers could maintain bans on open carry in their stores. The psychological impact may be immediate, fueling anxiety for some and relief for others. California now faces a reckoning over the visible presence of firearms in daily life. The Ninth Circuit's ruling reverberates far beyond California, challenging the gun control model of blue states nationwide. Socially, the prospect of open carry intensifies polarization. Some see it as a threat, others as a restoration of liberty. Public anxiety may rise, with fears of increased confrontations and a Wild West mentality. Supporters argue open carry deters crime and empowers citizens. The ruling provides a roadmap for challenging other gun laws under the Bruin test. If open carry bans fall for lack of historical precedent, other regulations, like background checks, could be next. This may be the first domino in a sweeping legal transformation. Legal experts are sharply divided on the Ninth Circuit's ruling and the Bruin test. Critics like UCLA's Adam Winkler call the historical standard unworkable, arguing it ignores modern realities and endangers public safety. They contend the founders couldn't have foreseen today's firearms or societal challenges. Supporters, like litigator Pete Patterson, say the Bruin test restores the Second Amendment as a fundamental right, not subject to judicial balancing. They compare it to First Amendment protections, demanding a high bar for government restrictions. For proponents, the ruling is a faithful application of constitutional principles. The debate now centers on whether history or modern needs should guide gun laws. The California case is part of a broader legal battle over American gun regulation post-Bruin. Courts nationwide are reconsidering laws on who can possess firearms, including those under restraining orders or with felony convictions. The Supreme Court will soon decide cases like United States versus Rahimi, which could reshape laws disarming dangerous individuals. Challenges to bans on assault weapons and high-capacity magazines are also underway, with courts split on historical justification. The legal landscape is unsettled, with more questions than answers. Can states ban guns on private property open to the public? Can the federal government bar gun ownership by drug users? Each case will be decided by historical analysis, not modern data. The nation's gun laws are entering uncharted territory. The Ninth Circuit's ruling marks a turning point, signaling courts' willingness to dismantle modern gun laws lacking historical roots. The debate now shifts from legislatures to history books, forcing 21st century America to look to the 18th century for answers. Appeals and conflicting court decisions will create confusion for citizens and lawmakers alike. If the Supreme Court upholds this standard, a wide range of gun laws could unravel. The core tension honoring constitutional tradition versus governing a modern, complex society. The future of gun rights will be shaped by the ongoing dialogue between past and present. The debate over the right to bear arms is more consequential than ever,